even though we do have some people connecting, so hopefully they can join us. But I want to say good afternoon to all, and thank you so much for being here with us at this webinar, especially on such short notice. We know you're very busy, so thank you so much for being interested in this major issue that we have currently in international law, and thank you for being here with us today. For those of you that don't know me, my name is Rosa Celorio, and I actually serve as Associate Dean for International and Comparative Legal Studies at UW Law School. And today we will be discussing the recent Russia's invasion of the Ukraine and its international law dimensions, implications, and impacts. And I am joined today by a group of our wonderful professors that have been discussing this very important event in their classrooms and also in the international law field. So I thought it would be very important to open a space, in our community at the law school to be able to delve into these issues more profoundly. The four professors that are going to be speaking with us today, they don't really need an introduction. I mean, I think you all know them. They're globally known in their areas of expertise, but I'm going to introduce them anyway. We have today with us Francesca Bignami, who's a Leroy Sorensen Merrifield Research Professor of Law at the law school. We also have Laura Dickinson, who is the Oswald Simister Colclough Research Professor of Law in the law school. We also have Sean Murphy, the Manab Professor of International Law. And we also have Ralph Steinhardt, the Lovinger Professor of Comparative Law and Jurisprudence at the law school. I'm very grateful to the four of you for being here today, especially those of you that just finished a class and sacrifice probably your recess, to be able to come and join us today at this event. And I wanted to share just some brief 5 thoughts with you before we actually begin the discussion today. One of them is that I think it's very important to recognize the importance of the historical moment in which we're at the moment. I think it's very important to acknowledge the alarming nature of what is happening in the Ukraine. And I was having actually a very interesting email discussion with Dean Tammy Tideswell this morning, in which both of us concluded that there are really no words to describe in many ways what's happening in the Ukraine at the moment. It is a mixture of alarm, of horror, of outrage, of tragedy, and of formidable human suffering. We're just recovering from a major pandemic globally, and now we're at war. And this is a difficult reality to face as we're seeing this daily on TV. And this is a conflict that not only affects the Ukraine and Russia, but it also has far-reaching implications and effects, when it comes to international law that we are going to be discussing today. There are many areas of international law that this conflict touches on. We're talking about humanitarian issues, human rights issues, criminal law issues, economic law components, and many others. I think it's also critical today to acknowledge the enormous human toll and the magnitude of this crisis. There are so many aspects, that really attest to that human toll. We're talking about the killing of civilians, the fleeing of 1 million refugees, the desperation of many to leave the Ukraine to safety, including children and women, and the strength of the Ukrainian people who are resisting with grit, with defiance, with determination, and with resilience. They're fighting for their self-determination, which is a critical right in international law. And from our ICL program, I want to send today a message of support and solidarity to all of those affected by this crisis, including some of our students and alums that are connected today. Much of what we're going to be discussing today are brazen and bold violations of international law. This is a situation that in many ways captures the fragility of international law, but it can also constitute a test of its strength, especially not only of the law, but also the relevance of all of these global and regional multilateral organizations. And as the events unfold, we are seeing the options that the international community has to address this kind of invasion. We have seen a multitude of sanctions. We're seeing matters before the ICJ and the ICC. We are seeing the involvement of the United Nations and its organs, NATO, and the European Union, among others. We're seeing all these forms of financial pressure and the exclusion of Russia from sporting events and other important international processes. And we're also witnessing a war on daily events on live TV. Much of what's happening is visible on TV, in social media, and in mass means of communication. This is a very public war in which much is being documented and seen as it unfolds. We're all left with lingering questions as the situation unfolds. Are these factors going to make a difference? And will they make this war shorter? Will international law and the existing global and regional organizations rise to the occasion and succeed in ending this war soon and addressing its consequences? Will sanctions and other measures work in this kind of situation, or do we need more? Will the international legal order ever be the same? What will happen to the 1 million refugees, to the millions of persons that have stayed in the Ukraine to fight, and to the future of the Ukraine? And will the resistance, resilience, and the human spirit in the Ukraine shorten this war? We will see, as President Zelensky has been saying. Without further ado, I thank you all for being here again. We will have some presentations from our professors now, and then I will open a space for questions and answers. And I now cede the floor to Professor Sean Murphy.
Thank you very much, Rosa, for that introduction and for those thoughtful opening comments. So I'll just lay out a little bit of the basic facts to be sure everybody's on the same page in this regard, and then talk a bit about some aspects of the law, leading to others, issues relating to the European Union and human rights and national security matters. So fast-moving events, I think we all know that, and the news reports are constantly changing in this regard. But I would say that the principal actions that have unfolded over the past week would include that Russia on February 21st decided to recognize 2 regions of eastern Ukraine, Donetsk and Luhansk, as independent states. No other country, to my knowledge, has followed Russia in recognizing these 2 new independent states, but it's a claim to take away pieces of a sovereign state of Ukraine. Then we had on February 24th, the Russian forces crossing the border into Ukraine at several places. Here too, the estimates differ, but somewhere between 100,000 and 190,000 Russian troops appear now to be within Ukraine. We've seen from the news reports Russian shelling, missile attacks, rocket attacks, air attacks on Ukrainian military intelligence and communications installations, but also now apparently attacks on several cities against civilian infrastructure. Separate from the Russian government directly doing this, there appear to be Russian-backed separatists operating in those 2 regions, Donetsk and Luhansk, also using military force to try to maintain and expand their own control. As Dean Solorio said, about 1 million refugees so far. I would just note that's the largest exodus of people in Europe since the early 1990s with respect to the Balkans. So it does give you a sense of what it is we're looking at here. I will note that Russia has placed its nuclear arsenal on high alert. That's a particularly concerning development, and one probably wants to keep that in the back of one's mind when we're thinking about possible reactions by other states. And perhaps worth noting that the country of Belarus allowed Russian troops to transit and deploy from it into Ukraine, which is why we're seeing some reactions, not just to Russia, but to the country of Belarus as well. Okay, turning to the law, let's start with the jus ad bellum, or the law on when it is a state can resort to a use of transboundary use of force. Many states, organizations, scholars have said that Russia's actions over this past week, deploying military forces into Ukraine, violates Article 2.4 of the UN Charter. That article, as many of you may know, states that all members shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state. And So unless Russia can plausibly make a claim of self-defense or plausibly make a claim of authorization from the Security Council, which it doesn't appear to be the case that it can, it leads to a conclusion that it's a violation of Article 2.4. I will note that Russia does claim a right of self-defense. It seems to be predicated on the idea of an ability to act to protect ethnic Russians in eastern Ukraine from what Russia claims are abuses by the Ukrainian government. Other states and observers don't see that, and consequently that claimed right of self-defense is not getting any traction. So we have had the UN Secretary General Antonio Guterres talk about Russia's actions as violating the UN Charter. We've seen that also from many countries, including President Biden, who called it a flagrant violation of international law. Ukraine is exercising a right of self-defense because it has been exposed to an armed attack. Most states, organizations, scholars have viewed Ukraine's conduct as falling within the scope of UN Charter Article 51, which preserves the inherent right of individual or collective self-defense if an armed attack occurs against a member of the United Nations. So Ukraine's military is fighting back. That resistance has slowed down Russian forces, as you will have seen in the news accounts. There have been Russian planes, even helicopters shot down. Ukraine is reporting about 6,000 Russian troops killed. Other states place the figure lower at about 2,000. Other states are reacting, but not by using force. So you might characterize what other states are doing as either retortion, which is the term we use when you engage in action that's otherwise lawful under international law, or these other actions are countermeasures, which means actions that normally might violate international law, perhaps a breach of a trade treaty or a breach of some other kind of treaty, but we excuse them as a permissible countermeasure when they are designed to bring about compliance by another state with a norm that they are obligated to uphold and have failed to do so. So what are these acts of retortion and countermeasures? We do have countries supplying Ukraine with anti-tank rockets, Stinger missiles, Javelin missiles, things of that sort. We have the US and the United Kingdom and the European Union moving to exclude the big Russian banks from the SWIFT system. That's the system for executing financial transactions and payments among banks worldwide. There's been a blocking of Russia's central bank assets to the tune of $643 billion in reserves, sanctions against assets of Russian officials and business leaders, sometimes referred to as oligarchs. Sovereign wealth funds invested in Russia are being sanctioned. We have many companies that have taken steps to distance themselves from Russia: Apple, ExxonMobil, Shell, Boeing, Meta, BMQ, Nike, Roku, Snap, Adidas, Maersk, the list goes on and on. The European Union and the United States and Canada have all closed their airspace to Russian planes. I would note that Russia has responded in kind. Turkey has closed the Dardanelles and Bosphorus Straits to warships passing through. That's based on Turkey's obligations under the Montreux Convention that arise in a time of war. We also have some sanctions on Belarus and on its officials, particularly targeting the timber industry, the steel industry, potash, things of that sort. These kinds of effects have had important effects on Russia. The value of the ruble has dropped 30%. The Russian stock market has dropped in value by 40%. A lot of major foreign investors are pulling out of Russia. Actions at the United Nations. The Security Council attempted to adopt a resolution condemning Russia's action, but that failed on February 25th due to the veto of Russia. So the Security Council 2 days later voted to refer the matter to the General Assembly under the Uniting for Peace resolution. And the General Assembly adopted yesterday a resolution in emergency session in which, by a vote of 141 in favor, 35 abstaining, and 5 against, it deplored in the strongest terms, and I'm quoting, the aggression of the Russian Federation against Ukraine in violation of Article 2.4 of the Charter, and demanded that Russia, and again I quote, immediately, completely, and unconditionally withdraw all of its military forces from the territory of Ukraine within its internationally recognized borders. So we've had that action there. As Dean Solorio noted, Ukraine has also sued Russia at the International Court of Justice. There will be a hearing this Monday and Tuesday on its request for interim measures of protection, which include getting out Russian troops out of Ukraine. I'll finish off by just noting that the International Criminal Court has indicated that it will proceed to investigate Russian actions in Ukraine that have occurred over the past couple of weeks that could lead to ultimately indictments relating to war crimes, crimes against humanity, and genocide. Lots more to be said, but I think my 10 minutes are up, so I'll leave it at that.
Thank you so much, Professor Murphy. Now we're going to turn to Professor Bignami, that's going to give us more the European perspective of what's happening and basically all of the movements from the international community and all the measures from the international community that Sean was referring to.
Thank you very much. So with my brief 10 minutes, I'm going to be focusing on 4 important elements of the EU's legal response to the crisis: financial sanctions, refugees, combating Russian disinformation, and military assistance. I'm going to take them in order of the policy areas where the EU as a supranational legal body, which governs in all EU 27, has the most experience first, and then I'll talk about those areas where it has little or no experience as a supranational political and legal body. So first, financial sanctions. The EU, as Sean just mentioned, has been engaged in widespread financial sanctions, and it has a pretty well-oiled regulatory system for freezing assets and stopping bad actors from using the EU's banks and financial markets. And this well-oiled regulatory system dates to 9/11 and the sanctions that were and that continue to be imposed on private and state actors that finance terrorism. And in the current crisis, it's being applied to Russian companies, banks, and individuals connected with the Russian government. The Council, where all 27 member states are represented, voted by unanimity to activate the system against a wide array of Russian persons and legal entities, and included the Russian Central Bank and Russian oligarchs whose assets have been frozen and who are prohibited from doing business. Now, the Council also agreed to suspend important Russian banks from SWIFT, which is the international system for bank transfers. And I had to say that even though the EU law on this is not particularly extraordinary, it's not new law that's being developed, the politics are. Nobody, I think, expected for the EU 27 to act so quickly to impose the financial sanctions and to impose them on such a wide array of actors connected to Russia. And even Hungary has gone along, and Hungary has been accused for years now of being Russia's Trojan horse in the EU, but it quickly went along. So that's financial sanctions. Second, the refugees. As we've already heard, there are 1 million Ukrainians who've already fled, and there are many more who are expected to flee the Ukraine. And the EU has legislation which is applicable in all 27 member states with respect to refugees under the 1951 Geneva Refugee Convention, as well as refugees who claim protection status under other sources of international and European human rights law. The main law is a Dublin regulation for asylum seekers, and this is what was used during the Syrian refugee crisis, and it's what is routinely applied in the EU 27. However, now the EU has just activated what's called the Temporary Protection Directive. And that gives temporary protection for people who are displaced in these kinds of crises that we see in the Ukraine. And under the Temporary Protection Directive, Ukrainians fleeing the Russian invasion are automatically given protection status. So that means they don't have to go through the very lengthy adjudication process that exists for asylum seekers. They're immediately given this status. It can last for up to 3 years, and it includes the right to residence permit and housing and other types of basic social rights. The member state where the refugee first enters is generally the member state with responsibility for giving the residence permit and decent reception conditions. And this obviously can lead to a real imbalance in burdens that are imposed on the member states, since border regions like Poland are obviously far more affected. But, and this is a contrast to the Syrian refugee crisis, Ukrainians are allowed, because of pre-existing law, to travel 90 days visa-free in the Schengen area, which is the border-free area that covers most EU countries. So there's the expectation that they will travel to join family elsewhere and obtain temporary status in member states that are not Poland or other countries at the border. And there's also the possibility in the directive, in the Temporary Protection Directive, for member states to voluntarily take refugees from the frontline countries. This is called relocation. And in the case of the Syrian refugees, this is very contentious, but nobody is hiding the fact that, given that we're dealing with a very different population ethnically, religiously, it will be less hard to agree on the redistribution of refugees among the EU 27. So that is refugees. Third, the EU is taking an action to combat Russian disinformation on the supposed persecution of Russian ethnic populations in the east of the Ukraine. So there's been a lot of disinformation online on that, and the EU has banned Russia Today and Sputnik. So all broadcast outlets, including cable TV, satellite, internet service providers, and social media, are prohibited from transmitting Russia Today and Sputnik. And this is very new for the EU, legally speaking. The EU has never, to my knowledge, taken this kind of action. It has a piece of legislation in the works that is called the Digital Services Act, and that would require social media companies and other outlets to take down illegal content, which does include fake news. But this is legislation that has not been passed yet. And so I think that this new action on Russia Today and Sputnik might be a dry run for the future on fake news. And so last and fourth, the EU has taken the unprecedented step of providing military aid directly to the Ukraine. And this is legally quite exceptional and new for the EU. So in terms of quantum of aid, it's very insignificant compared to other member states, or to the member states who are doing it bilaterally, so Germany, Sweden, etc. But sort of symbolically, it is very exceptional because the EU has never had powers in the defense and military zone or domain. The cards have generally all been held by the member countries. And now, however, since 2021, there's a new fund called the European Peace Facility, and it was established very recently, and it's being used to send 450 million euros worth of lethal equipment to the Ukrainian army, as well as 50 million euros worth of non-lethal equipment to the Ukrainian army. And therefore, even though the quantum is pretty insignificant in the grand scheme of things, politically, legally, symbolically, it's very important that the EU has now gotten involved in the military side. So I'll conclude there, looking forward to what my colleagues have to say in the other dimensions of this.
Thank you so much, Francesca. Now we go to Professor Steinhardt, who's going to really discuss the far-reaching human rights implications of this crisis.
Thank you, everybody. Many thanks to Dean Solorio for organizing this panel on such short notice. It's fantastic to be with you all, though like all of us, I wish the circumstances were not tragic as they are. I would like to speak briefly about this crisis through the lens of international human rights law. And I start with the reality that that international law continues a kind of epical move away from an exclusively state-centric body of law that, historically preserved more power for governments than it restrained, but towards a body of law that really obligates governments to protect human beings from abuse. This is a redefinition of sovereignty that is intergenerational. And it's a body of law that rests on the twin principles that human beings have rights simply by virtue of being human, and that governments are obliged to protect those rights in certain ways. I also think that it's important to say right at the beginning that this is in part a deeply pragmatic body of law. I realize it has a utopian or idealistic reputation, but it's important to understand that human rights law has a normative structure, it has an institutional structure, especially in this part of the world, but it also has served as the first successful ideology of unification and reconciliation in most of Europe. This is a continent riven by war and ideological conflict for centuries, but especially if you get over the recency bias that privileges the last week and focus instead on what human rights has meant politically or in the streets of Europe, I think we can begin to understand exactly that it is that it has this pragmatic value. We have to acknowledge, I think, that in the Council of Europe, for example, an organization created in the aftermath of World War II, now with 47 members, all of Europe except Belarus, that we now have an all-European system for the judicial and non-judicial protection of human rights that stretches from Greenland in the east to Vladivostok on the Russian Pacific coast. It covers 830 million people, almost a third of all the countries in the world, and that would have been inconceivable a few decades ago. And I hope we can be decent enough historians to catch the surprise that human rights should have found this productive momentum in the streets. Idea forces that have been internalized by individuals and governments and civil society, even as it's obvious that the system works better in some European countries than in others. I'd like to take my few minutes, if I might, to make three quick points, three quick ideas. One is to track out the human rights causes and the consequences of international conflict, as here. The second, that international human rights law remains in effect, that it continues to apply at all times, including during armed conflict and during occupation, to which the laws of war also apply. And then I want to close sort of defining the domain of international human rights law, to see how human rights law has pushed the mandates of intergovernmental organizations, as Professor Bagnami just demonstrated expertly with respect to the EU. But also to understand not just its institutional spread, but also its connection to other areas of the law that at least historically have been considered quite separate. Here I'm thinking of international criminal law, international refugee law. These are areas that have traditionally been kept separate from human rights law, but in our contemporary world, they're very much connected. These different areas of international law resemble one another, sort of like penguins in a flock of penguins, but they are, after all, different birds. And the Ukraine crisis, I think, illustrates a kind of Venn diagram of how these different subspecialties relate to one another. So very quickly, first, human rights causes and consequences of international conflict. I think the generation that survived World War II knows viscerally, and better than the rest of us, that wars and national security crises tend to be human rights crises in their late stages, after human rights have not been addressed or respected. The Organization for Security and Cooperation in Europe explicitly links security and stability in the region to respect for human rights, and that's where the ideology of reconciliation and unification and commonality has been most powerful. Here I want to invoke a mentor to many of us, a former colleague, a former judge on the Inter-American, on the Inter-American Court of Human Rights, but also on the International Court of Justice, Tom Bergenthal, who said that every great advance in human rights law has been the result of hypocrisy. Rank hypocrisy on the basis of governments is what drives human rights law And I think we are seeing that now, that we see human rights being violated. We even see human rights being invoked by the people who are violating the human rights. And we will see over time, I suspect, that accountability returns us to some measure of legality. The second point I want to make is that international human rights law remains in effect. It continues to apply at all times during armed conflict and occupation, to which the laws of war also apply. There are times in some circumstances when a norm of international humanitarian law or the law of war might trump a human rights norm. The more specific norm tends to trump the more general one. But Ukraine and Russia are both party to a number of regional and international human rights treaties, including the European Convention on Human Rights, the International Covenant on Civil and Political Rights, the Convention Against Torture and other cruel, inhuman, or degrading treatment or punishment. And those treaties all guarantee fundamental rights, many of which correspond to the rights which combatants and civilians are entitled to under international humanitarian law. So prohibition of torture, the requirements for non-discrimination, the right to a fair trial. Both the European Convention on Human Rights and the ICCPR permit some restrictions on certain human rights during wartime or an officially proclaimed public emergency that threatens the life of the nation. But these are strictly limited. They are exceptional, they must be temporary, they must be strictly required by the exigencies of the situation, to quote the treaty. And certain fundamental rights are non-derogable, even in those times, like the right to life, the right to be secure from torture, the prohibition on unacknowledged detention, the right to a fair trial. Those always have to be respected, even if the modalities of the trial can vary. And that's true even during a public emergency that threatens the life of the nation. If we look at the human rights law that applies, the Council of Europe certainly is key. Consistent with the statute of the Council of Europe, the Committee of Ministers last week suspended the Russian Federation from its rights of representation in the Committee of Ministers and in the Parliamentary Assembly. That has immediate effect, all because of the armed attack on Ukraine. The European Union, as Professor Bignami just demonstrated, has obviously deployed not just economic sanctions, but a military presence that, as she says, is quite unprecedented. The universal organizations for the protection of human rights include the Office for High Commissioner for Human Rights, which for 8 years has been involved in the situation in Ukraine, especially in the Donbass region, as well as in the Autonomous Republic of Crimea, as it's understood. And there are human rights monitors now for the High Commissioner for Human Rights in Ukraine. There's also the Office of the High Commissioner for Refugees, who we are looking at 1 million now crossing the border, but it is likely to be the largest. He said that it's likely to be the largest refugee crisis this century, with perhaps as many as 4 million people crossing a border or internally displaced. Finally, let me say just a word about defining the domains of international human rights law and talk a little bit about these penguins. International criminal law covers certain human rights atrocities. It's well understood that international criminal law, there's sort of 4 basic crimes, though others that we could look at, but 4 atrocity crimes: genocide, war crimes, crimes against humanity, and the crime of aggression. All of those, as Sean suggested, may well be the subject of investigations by the Office of the Prosecutor at the International Criminal Court. The crime of aggression is especially important. It was the top charge in the Nuremberg proceedings after World War II. And the final judgment at Nuremberg concluded, I'm quoting, "To initiate a war of aggression is not only an international crime, it is the supreme international crime, differing only from other war crimes in that it contains within itself the accumulated evil of the whole." So that the crime against the peace, which was prosecuted at Nuremberg, has been transformed now into the crime of aggression. And I suspect we will see those norms vindicated. Finally, international refugee law. This is framed by the 1951 Convention on the Protection of Refugees, but that was a somewhat narrowing regime and required someone to have crossed an international boundary for fear of persecution on certain designated grounds. We are not in that particular Kansas anymore. And the UN High Commissioner for Refugees has expanded the office's concerns to include those who are displaced, internally displaced persons, which we are likely to see in droves. 1 million refugees have crossed the international borders. Another million at the moment are internally displaced within those borders. And so these are areas of concern for the well-being of human beings that have generally been kept separate from international human rights law, but where I think you can see they are manifestations of the same sensibility. Thank you.
Thank you very much, Ralph. And now we move on to Professor Dickinson, who's going to discuss with us the cyber operations component of this crisis.
Thank you. Thank you, Dean Solorio, for putting together this event. You know, we're seeing this horrific tragedy unfolding before our eyes. And before I talk about the cyber component, I just want to echo what my thoughtful colleagues have said. And just note, I mean, we're seeing massive violations of international law, 3 bodies of international law, in particular, the Jus ad bellum, which Professor Murphy outlined, a clear violation of the prohibition on the use of force without justification or any of the permitted exceptions, probably so extreme that it's criminal, really serious cause to believe there might be criminal aggression there. Under international humanitarian law, we're seeing evidence that Russia may be targeting civilian infrastructure, which would be a violation of the principle of distinction, fundamental bedrock principle of international humanitarian law that is in most cases criminal if that is violated, and also the principle of proportionality. We're seeing potential violations there where under that principle military advantage has to outweigh harm to civilians and civilian objects. So that's very concerning. And also the use of cluster munitions, which are banned by many countries around the world and cause just tremendous civilian suffering, and many believe are indiscriminate weapons, and a violation of international humanitarian law as well. And then massive human rights violations, whether on the Russian side, where people are not allowed to protest the war and they're not even allowed to say the word war. And we've seen massive arrests of protesters in Russia, and then potentially violations of human rights by Russia in the Ukraine. But I want to turn now to the cyber dimension of this, which is sometimes harder to see, but which is a big component of this war. And what I want to argue is that it is exposing some significant gaps in each of these 3 bodies of law as it pertains to cyber operations. The big picture point is that, you know, there's been discussion over the last 15, 20 years about how to apply existing bodies of international law to cyber operations, which were not really contemplated at the time these bodies of law were developed. And there's consensus that when cyber operations have kinetic effects that mimic the kinetic use of force, then they fit within these existing paradigms. So for example, it would be a use of force under the Jus ad bellum, a prohibited use of force, if there are kinetic effects of the cyber operation. But the problem is that a lot of cyber operations do not have kinetic effects. And this is where they have tremendous effects on people, on civilian populations, but they do not have kinetic effects. And we are seeing evidence of this in this current war in Ukraine, and prior to the war in Ukraine, actions by Russia leading up to the war in Ukraine. And I want to highlight some of these issues specifically. So I'm going to highlight some of the gaps under the Jus ad bellum, how they apply to this conflict, gaps in the Jus in bello, and then gaps in human rights law. So first, with respect to the Jus ad bellum, prohibition on the use of force, prior to the invasion, the kinetic invasion, we had reports of a massive cyber operation that was wiping data on Ukrainian government in Ukrainian government facilities. This is the kind of cyber operation that doesn't necessarily have a direct kinetic effect that can be shown, but has a lot of harm if that data is deleted or taken. For example, the Russians might be using it to get information about how they're going to conduct their military operations now that they're involved in the war. They might later use it. There have been reports they're planning to target and assassinate individuals within Ukraine, get information about people within Ukraine, right? It can have potentially very damaging effects, but it's not, most would agree, that is not a use of force under the jus ad bellum. Deleting data is not a use of force. Now, there's also a standard in the jus ad bellum that prohibits interference with sovereignty. There's a little bit more debate about when operations against data or computer systems might violate sovereignty, but even there, it's not entirely clear. So that exposes kind of gaps in our international legal system here when it applies to cyber operations. Those cyber operations can be very, very damaging. But it's not clear that they cross the line under the jus ad bellum. Then if we go into the armed conflict itself, there's real uncertainty about how these fundamental principles of the law of armed conflict, of international humanitarian law, would apply to cyber operations that are likely taking place. Now, one of the things about cyber operations is that they often are not visible. So we don't have as much information about them as we do about the bombs that are being dropped right now. But let me give you some examples of the gaps in existing international humanitarian law when it comes to cyber operations that do not have a clear kinetic effect, that is, operations to acquire, attack, delete data, which do have a big impact, if not kinetic. So, for example, it is not clear whether an operation to delete data in an armed conflict is actually an attack that would be subject to the rules regarding attacks under international humanitarian law, rules including proportionality and distinction. That's not clear. Now, there are some rules that would apply beyond attacks that would still apply, but it is unclear whether operations against data are subject to those rules. And then even if they are, when data itself is attacked, there's a question about whether data is an object. Military objects can be attacked if other rules are followed. Civilian objects cannot. But is it even an object within the meaning of those rules? Scholars, policymakers, government lawyers disagree. And then furthermore, how do you distinguish, assuming it is an object, how do you distinguish between civilian and military data to determine what may be attacked and what may not? Data is often stored in a way that is commingled. It's often stored outside the battlefield as well. So that presents a lot of challenges and a lot of issues. Furthermore, for a proportionality analysis, how do you calculate civilian harm? Does harm to data, privacy harms, capturing data that could then be used for other purposes, is that supposed to be included in a proportionality analysis? Again, these are some of the fundamental gaps in the law. Then I could say a lot more about IHL, but I want to say briefly that we have some of the same challenges with respect to human rights law. Now, human rights law more clearly prohibits things like violations of privacy, but there are problems regarding the extraterritorial application of human rights law, disagreements about whether it applies to a state's behavior extraterritorially. So Russia acting in Ukraine, if it's acquiring data and using that data, there are some issues there regarding how and when the human rights law applies. And also things like privacy in human rights law do have more limitations and are derogable. Those derogations, as my colleague Professor Steinhardt said, have to be strictly limited, but nonetheless, there's more wiggle room there for those kinds of rights. So the other issue is the role of non-state actors. And human rights law very clearly regulates state conduct. There are various theories about how state actors are regulated under human rights law, but it's a harder question. States are responsible to respect and ensure that actors within their states don't violate rights, but it's still harder to regulate non-state actors, and non-state actors are very much involved in many cyber operations. The law of state responsibility comes into play as well. When are states responsible for actions that they encourage? Ukraine has encouraged people to join a kind of IT army to attack Russia with cyber attacks. To what extent would Ukraine be responsible for those actions? There are many other issues we could raise. What is the scope and scale of the armed conflict when we have cyber operations taking place related to the Ukraine conflict outside of Ukraine? Does that expand the scope of the armed conflict, for example, to Russia? And more. So there are more issues we could raise, but I just wanted to spotlight that this is an example where we are seeing cyber operations. I'm sure we'll hear more about them as time unfolds. It is significant. Many people are saying that Russia has not been able to cut off the communication systems within Ukraine. And so the Ukrainians are actually using communications very effectively right now, but we may see Russia cutting off communication systems of Ukraine in the near future. The last thing I just want to say, big picture point, this is a real attack on the rules-based international order. In some ways, we're seeing the strength of international law and institutions, but I think there are also real weaknesses that are being exposed, and I think the jury is really out on how effective international law and international institutions can be to deal with these blatant violations when you have a powerful nuclear state committing them. I'll stop there.
Thank you so much, Professor Dickinson, and thank you to all of the speakers today for your insightful and thoughtful remarks on an ongoing situation and in a very complex situation, and one that we're going to be discussing for sure for a long time. I want to make sure that we have time for questions. We have a number of questions in the chat, so I'm going to read some of those for our speakers. One of them is from Priyanka Raj, and she's asking how powerful or how impactful the International Criminal Court could be in this situation, not only in prosecuting, but also stopping war crimes and the humanitarian crisis and the genocide that we're seeing in this situation. We also have a question from Olena Mikhailchenko, and I just want to say that I had the honor of working very closely with Olena when she was an LLM student at GW Law School. And she's personally affected by the situation. She's from the Ukraine. She has family over there. And I just want to tell you, Olena, that we stand by you. We support you in this very complicated situation. And she's asking about the effectiveness of the United Nations in this situation. You know, what are we seeing? And I would add to that question, you know, what does this situation say about the Security Council and the state of the Security Council at the moment at the United Nations level? And then we have a question also from Destiny Johnson Amanda, and she's asking, are there any provisions being made by the European Union and the international community to protect basic human rights of the non-Ukrainian populations that are affected by this crisis? And she mentions in particular, for example, communities of, you know, Afro descent and other communities that may be non-Ukrainian that are affected by this situation. I leave the floor open for any of our speakers who would like to take a shot at those questions. Sean.
Sure. Well, great questions. I detect in at least the first two, maybe all three of those questions, a deep desire that international law and international institutions would have some way of immediately stopping things that are happening right now. And unfortunately, that's not the system we have. We don't have a world government with a global police force on our beck and call to swoop in and do things. States just haven't set up that system. They haven't wanted that. They don't want to have someone swooping in on them in some way. So I think that it's probably asking too much that the International Criminal Court or the United Nations or the European Union or any other body would have some ability to tomorrow stop these things. I think instead what we have is a system where there's rules, and those rules allow us to talk about what's going on and confront actions that are taking place as being wrongful. And I think that's what we are seeing here. And a system that relies heavily on countermeasures by states against malfeasant states in order to try to induce their compliance. So, I think everything that we've talked about, all the different institutional structures, all the rules are pressure points for bringing about compliance, but that doesn't necessarily mean it will result in compliance, certainly not in the very short term. I do want to say one other thing about the International Criminal Court. Although it has within its jurisdiction the crime of aggression, when that crime was activated, the amendments that did so precluded its application to any state that was not a party to the Rome Statute or that had not ratified those amendments. Russia is not a party to the Rome Statute, so they're not exposed to the crime of aggression at the ICC. That's different from whether it might be exposed to an ad hoc international criminal tribunal, which could be created even under the recommendation of the General Assembly, as was done with Cambodia. So if the Secretary General was asked by the General Assembly to, in conjunction with Ukraine, create an ad hoc tribunal, that would be a possibility. But the only crimes at the ICC that could currently be pursued against Russia for acts occurring in Ukraine would be war crimes, crimes against humanity, and genocide. Thanks.
Thank you, Sean. Ralph?
I just want to respond to the first question about what we can do to stop this. I just want to agree with Sean that we don't have that system at the moment. On the other hand, I think it's a really crucial perspective that no law can prevent its own violation, right? The securities laws do not by themselves prevent every fraud. The antitrust laws do not stop every restraint of trade. The question for lawyers is, what are the consequences? What do we do as a result of these clear breaches, as Professor Dickinson pointed out? What are the consequences? And that's really, I think, what we're talking about. And it's very difficult at the moment to predict entirely what those will be. But let's not miss the extraordinary unified response over the last week, where organizations like the EU are pushing on their mandates and their history and their culture to take extraordinary steps. I also want to respond to Destiny's question, because I had in my notes, don't forget to mention the racial discrimination element, especially when it comes to refugees. And I didn't get to that, and I'm sorry. But just a few hours ago, the UN Special Rapporteur on Contemporary Forms of Racism, Tendai Achiume, expressed exactly these concerns about racist threats or xenophobic treatment against non-white people fleeing Ukraine. And she issued a statement that in her words, The reality is that non-white migrants and refugees face deadly discrimination all over the world as they attempt to cross international borders. The images and testimonies from non-white people attempting to flee Ukraine attest to this fact, and they should motivate immediate action to ensure that racist and xenophobic treatment, whether official or unofficial, is brought to an end. So I think that, again, the mechanisms are in place to address that very significant problem.
It's 1 o'clock, so unfortunately we have reached the end of our event, but I want to thank so much all of our professors for their remarks today and for their time today, especially on such short notice. This shows their commitment, to the advancement of international law and to using their knowledge, to educate and help us navigate this kind of crisis. I also want to thank all of you for connecting today and for being concerned about the situation. And I close this event today with a message of hope that peace comes soon, and a message of solidarity to all of those gravely affected by this ongoing crisis. Thank you so much, and I hope you have a good rest of the day.
Thank you.
Thank you, professors.
Thank you very much. Bye-bye.